Surgeons are trained to make impossible decisions under pressure. And sometimes, patients don't survive. That's what made this case so difficult to see at first. Each death had an explanation. Each mistake had a justification. Until one patient didn't die. And what they described didn't match the surgical report. Suddenly, years of accidents began to form a pattern. And the doctor who claimed to save lives was forced to explain how so many ended instead. The hospital had a reputation for excellence. It was a teaching hospital. Large, well-funded. It served a major metropolitan area on the West Coast. It had state-of-the-art equipment. A renowned cardiac unit. A trauma center that handled the most critical cases. The staff was experienced. The protocols were rigorous. The outcomes were generally good. But in one department, the mortality rate had begun to climb. Not dramatically. Not enough to trigger immediate alarm. But enough that the numbers, when reviewed over several years, showed a troubling trend. Patients who should have survived routine surgeries were dying from complications. Infections. Hemorrhaging. Organ failure. Each death was reviewed by the hospital's Mortality and Morbidity Committee. Each review concluded that the complications, while unfortunate, were within the expected range for high-risk surgeries. The surgeon at the center of most of these cases was well regarded. He had been with the hospital for over a decade. He had trained at prestigious institutions. He published research. He mentored residents. His colleagues respected him. His supervisors trusted him. And when questions were raised about his outcomes, he had answers. The patients were high risk. They had comorbidities. They were older. They were sicker than average. The explanations were medically sound. They were consistent with the complexity of the cases. And so the deaths continued to be classified as unfortunate but unavoidable. Until one patient survived. And what that patient remembered contradicted everything the surgeon had documented. The case began not with a death, but with a recovery that should not have been necessary. A patient had undergone what was supposed to be a routine surgical procedure. The surgery had been completed. The patient had been moved to recovery. But within hours, the patient's condition deteriorated rapidly. Severe internal bleeding. Unexplained pain. Vital signs dropping. The patient was rushed back into emergency surgery. A different surgical team took over. They worked through the night to stabilize the patient. When they opened the surgical site, they found something unexpected. A major blood vessel had been damaged. Not nicked. Not accidentally grazed during a difficult maneuver. Damaged in a way that should not have occurred during the type of procedure that had been performed. The vessel had been partially severed. And the damage had been inadequately repaired. The second surgical team corrected the problem. They stopped the bleeding. They stabilized the patient. The patient survived. But the lead surgeon on the emergency team filed a report. He documented what he had found. He noted that the damage to the blood vessel was inconsistent with the original surgical approach that had been documented in the operative report. The report was forwarded to the hospital's Quality Assurance Department. Quality Assurance reviewed the case. They requested the operative report from the original surgery. They reviewed the surgical notes. They interviewed the surgical team. The original surgeon was asked to explain the discrepancy. He said the blood vessel injury had occurred during the procedure. He said it had been a known complication. He said he had repaired it at the time. He said the patient must have experienced delayed bleeding, a suture failure, something that could not have been predicted. The quality assurance team asked why the vascular injury had not been documented in the operative report. The surgeon said it had been documented. He pointed to a line in his notes that mentioned minor vascular involvement, controlled. The emergency surgeon who had performed the second operation was asked to review that documentation. He said the phrase minor vascular involvement did not accurately describe the extent of the damage he had found. He said the injury he had repaired was not minor. It was significant. And it had been inadequately addressed. The quality assurance team asked if the emergency surgeon was suggesting the original surgeon had made an error. The emergency surgeon said he was stating what he had observed. He said the injury pattern did not match the procedure that had been documented. The quality assurance team asked what he meant by that. The emergency surgeon said the blood vessel that had been damaged was not in the surgical field for the procedure that had been performed. It was adjacent, but it should not have been touched, unless the surgeon had deviated from the planned approach, or unless the injury had been inflicted intentionally. The emergency surgeon did not use that word in his report, but the implication was clear. The quality assurance department escalated the matter to the hospital's risk management team. Risk management reviewed the case alongside the hospital's legal counsel. They determined that the case presented potential liability, but they also determined that proving intentional harm would be difficult. The original surgeon had provided a plausible explanation. The injury could have occurred accidentally. The documentation, while vague, was not definitively false. And the patient had survived. There was no fatal outcome to investigate. Risk management recommended that the case be monitored, that the surgeon's future cases be reviewed more closely, but they did not recommend disciplinary action. The hospital's chief of surgery was informed. He reviewed the case. He agreed with the recommendation. He met with the surgeon privately. He told him that there had been concerns raised about the documentation in the case. He advised him to be more thorough in his operative reports going forward. The surgeon agreed. He said he understood. He said he would be more careful. The matter was considered closed. But the patient who had survived began asking questions. The patient's name was not released publicly at this stage. But for the purposes of the investigation that would follow, she became known as Patient A. Patient A had undergone the surgery in the spring. By summer, she had recovered enough to review her own medical records. She requested copies of her surgical reports. She read through them carefully. She was not a medical professional, but she was intelligent, educated. She worked in a technical field. She understood documentation. She understood when something didn't add up. And the operative report from her first surgery did not match what she remembered. She remembered the surgeon telling her before the procedure that it would be straightforward. Low risk. She would be out of the hospital in 2 days. But after the surgery she had nearly died. She remembered the emergency surgery. She remembered the second surgeon explaining that there had been a complication, that a blood vessel had been damaged, that it had required extensive repair. But when she read the operative report from the first surgery, it described the procedure as routine, successful. No significant complications. Patient A contacted the hospital. She asked to speak to someone in patient advocacy. She explained her concerns. She said the documentation did not match her experience. She said she wanted to understand what had happened. The patient advocate listened. She took notes. She said she would forward the concerns to the appropriate department. Patient A never received a follow-up. She contacted the hospital again. This time, she asked to speak to the risk management department. She was told that her case had already been reviewed, that the matter had been resolved, that there were no findings of misconduct. Patient A asked to see the findings. She was told that internal review documents were not shared with patients. Patient A consulted an attorney. The attorney's name was Richard Gaines. He specialized in medical malpractice. He had been practicing for 20 years. Gaines reviewed Patient A's medical records. He reviewed the operative reports. He reviewed the documentation from the emergency surgery. He saw the same discrepancies that Patient A had seen. He requested additional records from the hospital. Nursing notes, anesthesia records, post-operative assessments. He found more inconsistencies. The nursing notes from the recovery room indicated that Patient A had reported severe pain immediately after the first surgery, pain that was described as 10 out of 10 and unrelenting. But the surgeon's post-operative note described the patient as stable and comfortable. The anesthesia records showed that Patient A's blood pressure had begun dropping within 2 hours of the surgery, that additional fluids had been administered, that the anesthesiologist had noted concern about possible internal bleeding. But the surgeon's note from that same time period made no mention of bleeding concerns. Gaines knew that discrepancies in medical documentation were not uncommon. Doctors were busy. Notes were sometimes written hastily. Details were sometimes missed. But this was different. This was a pattern of documentation that minimized complications, that downplayed warning signs, that created a narrative of success when the reality had been near catastrophe. Gaines filed a formal complaint with the state medical board. The medical board opened an investigation. They requested all records related to Patient A's case. They also requested records for all surgical cases performed by the surgeon over the past 5 years. The hospital complied. They provided thousands of pages of documentation. The medical board assigned an investigator to review the records. The investigator was a physician. He had experience in surgical quality review. He began with Patient A's case. He confirmed the discrepancies that Gaines had identified. Then he moved to the other cases. He reviewed every surgery the surgeon had performed in the past 5 years. He noted the outcomes. He noted the complications. He noted the mortality rate. The mortality rate was higher than average. but not dramatically so. The complication rate was higher than average, but again not enough to trigger automatic concern. But when the investigator looked more closely at the cases that had resulted in death, he found a pattern. In nearly every case, the operative report described the surgery as successful or routine, but the subsequent clinical notes described severe complications that had developed rapidly after the surgery. Infections, hemorrhages, organ failures. Complications that, according to the medical literature, should have shown warning signs during or immediately after surgery. But in the operative reports, those warning signs were absent. The investigator requested to interview the nurses and residents who had assisted in those surgeries. The interviews took place over several months. The nurses and residents were cautious. They were still employed by the hospital. They were concerned about retaliation. But when assured that their statements would be confidential, several of them began to describe concerns they had raised at the time. One resident described a surgery in which the patient had experienced significant bleeding during the procedure. The resident had asked if they should call for additional support. The surgeon had said no. He had said he could handle it. The patient had died 2 days later from internal bleeding. The resident said he had been surprised when he read the operative report. It made no mention of the intraoperative bleeding. Another nurse described a case in which the patient had been in severe pain in the recovery room. The patient had said something felt wrong. The nurse had paged the surgeon. The surgeon had come to the recovery room, examined the patient briefly, and said the pain was normal post-operative discomfort. The patient had died that night from sepsis. The nurse said she had documented the patient's complaints in her notes, but she said the surgeon's post-operative assessment had dismissed them. A second resident described a case in which he had noticed that a surgical drain had not been placed correctly. He had pointed it out to the surgeon. The surgeon had told him not to worry about it. He had said it would be fine. The patient had developed a massive infection and died within a week. The resident said he had been told by senior staff not to question the surgeon's judgment, that the surgeon was experienced, that complications happened. The investigator documented all of these statements. He compiled them into a report. The report concluded that there was sufficient evidence to suggest a pattern of substandard care, and that the surgeon's documentation consistently failed to reflect the severity of intraoperative complications. The report stopped short of alleging intentional harm, but it recommended that the surgeon's license be reviewed. The medical board referred the case to their disciplinary committee. The disciplinary hearing was scheduled for the following year. In the meantime, Gaines continued his investigation on behalf of patient A. He identified 12 patients who had died following surgeries performed by the surgeon over a 7-year period. He contacted the families of those patients. Most of them had accepted the deaths as tragic but unavoidable. They had been told by the hospital that their loved ones had been high risk, that the surgeries had been necessary, that everything possible had been done. But when Gaines described what he had found in patient A's case, several of the families agreed to allow him to review their loved ones' medical records. Gaines requested the records. He reviewed them with the help of medical experts. The experts found the same patterns. Operative reports that described successful procedures. Clinical notes that described rapid deterioration. Deaths that occurred within days of surgery. And in several cases, autopsy reports that identified causes of death that should have been preventable. One patient had died from a bowel perforation that had not been identified during surgery. The autopsy showed that the perforation had occurred in a section of the bowel that should not have been involved in the surgical procedure. Another patient had died from cardiac arrest caused by uncontrolled bleeding. The autopsy showed that a major artery had been damaged during surgery. The damage had been inadequately repaired. A third patient had died from septic shock. The autopsy showed that a surgical instrument had been left inside the abdominal cavity. Gaines compiled all of this evidence. He filed a civil lawsuit on behalf of patient A and 3 of the families. He also contacted the district attorney's office. The district attorney's office reviewed the evidence. They assigned a prosecutor to the case. The prosecutor's name was Helen Ortega. She had experience in complex criminal cases. She had prosecuted medical fraud. She had prosecuted cases involving professional misconduct. But she had never prosecuted a doctor for murder. Ortega reviewed the medical records. She reviewed the expert reports. She reviewed the statements from nurses and residents. She consulted with the medical examiner's office. She asked if the deaths could be classified as homicides. The medical examiner said it was possible, but it would require proving that the deaths were the result of intentional acts, not negligence. Ortega said that was the question she needed to answer. She requested all records related to the surgeon's employment history, his training, his background. She requested records from every hospital where he had worked prior to his current position. And she found something. The surgeon had worked at 3 other hospitals before joining the current institution. At each of those hospitals, he had left under circumstances that were not entirely clear. At the first hospital, he had resigned after 2 years. The personnel file indicated that the resignation had been voluntary. But there were notes in the file suggesting that there had been concerns about his judgment. At the second hospital, he had been asked to leave after a patient complaint. The details of the complaint were not in the file, but the departure had been negotiated quietly. At the third hospital, he had been placed on administrative leave following a mortality review. The leave had lasted 6 months. Then he had resigned. Each departure had been followed by a positive reference letter. Each letter praised his technical skills, his dedication, his professionalism. None of the letters mentioned the reasons for his departure. Ortega contacted the administrators at each of those hospitals. She asked for the full personnel files. She asked for any documentation related to patient complaints or mortality reviews. Most of the hospitals were reluctant to provide the information. They cited confidentiality. They cited legal concerns. But Ortega obtained subpoenas. And eventually the records were produced. The records showed a pattern that stretched back over 15 years. At each hospital, there had been patient deaths. At each hospital, there had been questions about the surgeon's decision-making. At each hospital, the matter had been handled internally, quietly. And at each hospital, the surgeon had moved on before any formal disciplinary action could be taken. Ortega realized she was not looking at a single case of malpractice. She was looking at a serial offender. Ortega presented her findings to the district attorney. She recommended filing criminal charges. Not for malpractice. For murder. The district attorney asked if she could prove intent. Ortega said the pattern suggested intent. The falsified documentation suggested intent. The repeated nature of the conduct suggested intent. But she acknowledged that proving intent in a medical context would be difficult. The defense would argue that the deaths were the result of poor judgment, of errors under pressure, of the inherent risks of surgery. The district attorney asked if Ortega had a theory of motive. Ortega said she did not. Not yet. But she said motive was not required to prove murder. Only intent. The district attorney authorized her to continue the investigation. But he cautioned her that the case would require extraordinary evidence. Ortega began building that evidence. She started by re-interviewing the nurses and residents who had worked with the surgeon. This time she asked different questions. She asked if they had ever seen the surgeon behave in ways that seemed inconsistent with patient care. She asked if they had ever seen him make decisions that seemed to prioritize something other than the patient's well-being. She asked if they had ever felt uncomfortable with his approach. Several of them said yes. One nurse described a case in which the surgeon had seemed irritated by a patient's questions. The patient had been asking about risks, about alternatives. The surgeon had become short with the patient. He had told the patient to trust him. The patient had died following the surgery. Another resident described a case in which the surgeon had ignored standard protocols. The resident had suggested following the established approach. The surgeon had dismissed the suggestion. He had said he knew what he was doing. The patient had experienced severe complications and had required additional surgeries. A third nurse described a case in which the surgeon had seemed rushed, distracted. She had asked if he wanted to reschedule the surgery. He had said no. He had said he needed to get it done. The patient had died on the operating table. None of these observations on their own proved intent, but together they suggested a pattern of recklessness, of prioritizing his own schedule, his own convenience, over patient safety. Ortega continued digging. She obtained the surgeon's financial records. She was looking for anything that might explain a motive: gambling debts, financial pressure, anything that might have driven him to take risks. She found nothing unusual. His finances were stable. He earned a substantial income. He had no significant debts. She obtained his personal communications, emails, text messages. She was looking for any indication that he had been aware of the harm he was causing, any acknowledgement, any expression of guilt or concern. She found very little. The communications were mundane, professional. There was no smoking gun. But there was one exchange that caught her attention. It was an email thread between the surgeon and a colleague. The colleague had asked him about a case, a patient who had died following a surgery the surgeon had performed. The colleague had written, I heard about the Johnson case. That's tough. How are you holding up? The surgeon had responded, these things happen. Can't save them all. The colleague had written back, I know, but still. 3 in 1 month. That's rough. The surgeon had responded, high-risk patients. They knew the odds. Ortega noted the exchange. She requested records for all surgeries the surgeon had performed during that month. She found that 3 patients had indeed died. All within a 4-week period. All from complications that the operative reports had described as unexpected. Ortega began to form a theory. She believed the surgeon was not killing patients for financial gain. He was not killing them out of malice. He was killing them out of arrogance. He was performing surgeries that he knew were high risk. He was taking shortcuts. He was ignoring warning signs. He was prioritizing his own convenience over patient safety. And when patients died, he rationalized it. He blamed the patients. He blamed their conditions. He blamed chance. He never blamed himself. Ortega believed this was not negligence. It was reckless indifference to human life. And under the law, reckless indifference could constitute murder. She drafted an indictment. The indictment charged the surgeon with 15 counts of second-degree murder. Each count corresponded to a patient death that Ortega believed had been caused by the surgeon's reckless conduct. The indictment also charged him with multiple counts of falsifying medical records. The charges were filed in the spring of the following year. The surgeon was arrested at his home. He posted bail within hours. He retained a prominent defense attorney. The attorney's name was Marcus Hale. He had built his career defending high-profile clients. He had won cases that seemed unwinnable. Hale immediately filed motions to dismiss the charges. He argued that the deaths were the result of medical complications, not criminal conduct. He argued that the prosecution was criminalizing medicine, that it would have a chilling effect on doctors' willingness to take on high-risk cases. The motions were denied. The case was assigned to Judge Patricia Navarro. She had been on the bench for 12 years. She had a reputation for being meticulous, fair, and unwilling to tolerate theatrics. The trial was scheduled to begin in the fall. Jury selection took 3 weeks. Ortega used her voir dire to identify jurors who could understand the difference between unavoidable complications and reckless disregard. Hale used his voir dire to identify jurors who would be skeptical of a prosecution that seemed to second-guess medical decisions. The final jury was seated in October. 8 women. 4 men. 2 alternates. Judge Navarro instructed the jury on the charges. She explained that the prosecution would need to prove that the defendant had acted with reckless indifference to human life, that his conduct had directly caused the deaths of the patients, and that he had knowingly falsified medical records to conceal his actions. She explained that the defense would argue that the deaths were tragic but unavoidable complications, that the defendant had acted within the standard of care, and that any errors in documentation were the result of oversight, not intent to deceive. She told the jury to listen carefully to the evidence, to consider it objectively, to set aside any preconceptions about doctors or about the medical profession. Then she invited the prosecution to make their opening statement. Ortega stood and walked to the center of the courtroom. She did not use notes. She spoke directly to the jury. She told them that this case was about trust. Patients trust their doctors to do everything possible to save their lives. They trust that the decisions their doctors make are in their best interest. They trust that if something goes wrong, it will be documented honestly. She told them that the defendant had violated that trust. Not once, not twice, but 15 times. She told them that the evidence would show a pattern of surgeries that went wrong, of patients who died when they should have survived, of documentation that concealed what had really happened. She told them that the defendant was a skilled surgeon. He knew what he was doing. He knew when he was taking risks. He knew when he was cutting corners. And he did it anyway. Ortega told the jury that they would hear from nurses who had questioned his decisions, from residents who had raised concerns, from patients who had survived his surgeries and could describe what they had experienced. She told them they would see medical records that had been falsified, operative reports that did not match the clinical reality, documentation that had been designed to protect the defendant, not the patient. She told them that the defendant had believed he was untouchable, that his position, his reputation, his credentials, would protect him from scrutiny. But Ortega told the jury that no one was above the law, not even a doctor. She asked them to hold the defendant accountable. Hale stood for the defense. He began by acknowledging that the case involved tragedy, that 15 families had lost loved ones, that those losses were real and painful. But he told the jury that tragedy does not equal murder. He told them that the defendant was a surgeon, that he had dedicated his life to saving lives, that he had performed thousands of surgeries over his career, that the vast majority of his patients had survived and thrived. He told them that surgery was inherently risky, that complications occurred even when everything was done correctly, that patients who were sick, who were elderly, who had multiple health problems, sometimes did not survive despite the best efforts of their doctors. Hale told the jury that the prosecution wanted them to believe that the defendant had intentionally harmed his patients. But he said there was no evidence of that. No motive. No confession. No witnesses who could testify that the defendant had deliberately caused harm. He told them that what the prosecution was really doing was second-guessing medical decisions with the benefit of hindsight, that they were looking at outcomes and working backward to assign blame. He told them that the medical records the prosecution claimed were falsified were simply incomplete, that doctors wrote operative reports based on what they believed was most important, that they did not always document every minor detail. Hale told the jury that the defendant had made mistakes, that he would be the first to admit that, but mistakes were not crimes. He told them that if they convicted the defendant, they would be sending a message to every doctor in the country. A message that if a patient dies, the doctor could go to prison. He said that would destroy medicine as we know it. He asked the jury to find the defendant not guilty. The prosecution called its first witness. It was patient A. She took the stand. She was sworn in. Ortega asked her to describe her experience. Patient A said she had undergone what was supposed to be a routine surgical procedure. She said the defendant had told her it was low risk, that she would recover quickly. She said that after the surgery she had been in more pain than she had expected. Severe pain. She had told the nurses. The nurses had given her medication, but the pain did not subside. She said she had felt something was wrong. She had asked to see the surgeon. He had come to her room. He had examined her briefly. He had told her the pain was normal, that it would get better. But it didn't get better. It got worse. She said that by the next morning she could barely breathe. Her blood pressure was dropping. She was rushed to emergency surgery. She said the second surgical team had saved her life. Ortega asked if she had reviewed her medical records after she recovered. Patient A said yes. Ortega asked what she had found. Patient A said the operative report from her first surgery described the procedure as successful. No complications. Everything routine. But she said the emergency surgery report described extensive damage. A blood vessel that had been severed. Internal bleeding that had been life-threatening. Ortega asked if the two reports seemed consistent. Patient A said no. Ortega asked if she believed the defendant had been honest with her about what had happened during the surgery. Hale objected. He said the question called for speculation. Judge Navarro sustained the objection. Ortega rephrased. She asked if the defendant had ever explained to Patient A how the blood vessel had been damaged. Patient A said no. She said he had never discussed it with her. Ortega had no further questions. Hale cross-examined Patient A. He asked if she was a medical professional. She said no. He asked if she had surgical training. She said no. He asked if she understood the technical details of the procedure she had undergone. She said she understood what the surgeons had explained to her. Hale asked if she understood that complications could occur even when a surgery was performed correctly. She said yes. Hale asked if the defendant had ever told her that the surgery was risk-free. She said no. He had said it was low risk. Hale asked if she understood the difference. She said yes. Hale asked if the defendant had acted quickly when her condition deteriorated. She said he had come to see her when the nurses called him. But she said he had told her everything was fine. Hale asked if the defendant had been the one who ultimately ordered the emergency surgery that saved her life. She paused. She said she didn't know. She said she had been unconscious by that point. Hale had no further questions. Ortega called her next witness. The emergency surgeon who had operated on Patient A. His name was Dr. Leonard Krauss. He had been practicing for 18 years. He specialized in trauma and emergency surgery. Ortega asked Dr. Krauss to describe what he had found when he operated on Patient A. Dr. Krauss said he had found significant internal bleeding. He said the source of the bleeding was a partially severed blood vessel. He said the vessel was a major branch of the mesenteric artery. Ortega asked if that type of injury was common in the type of surgery Patient A had undergone. Dr. Krauss said no. He said the mesenteric artery was not typically in the surgical field for that procedure. He said the injury should not have occurred unless the surgeon had deviated significantly from the standard approach. Ortega asked if Dr. Krause had reviewed the operative report from the original surgery. He said yes. Ortega asked if the operative report mentioned damage to the mesenteric artery. Dr. Krause said it mentioned minor vascular involvement. But he said that phrase did not accurately describe what he had found. Ortega asked if Dr. Krause believed the injury had been adequately repaired during the original surgery. Dr. Krause said no. He said the repair had been incomplete. He said that was why patient A had continued to bleed. Ortega asked if that suggested negligence. Hale objected. He said the question called for a legal conclusion. Judge Navarro sustained the objection. Ortega rephrased. She asked if the injury and the inadequate repair were consistent with the standard of care. Dr. Krause said no. Ortega had no further questions. Hale cross-examined Dr. Krause. He asked if Dr. Krause had been present during the original surgery. Dr. Krause said no. Hale asked if Dr. Krause knew what challenges the defendant had faced during that surgery. Dr. Krause said no. He said he only knew what was documented. Hale asked if it was possible that the defendant had encountered anatomical variations, that the patient's anatomy had not been typical. Dr. Krause said it was possible. Hale asked if anatomical variations could make surgery more difficult, more unpredictable. Dr. Krause said yes. Hale asked if it was possible that the defendant had done the best he could under the circumstances. Dr. Krause paused. He said it was possible. But he said the outcomes suggested otherwise. Hale asked if outcomes were always reflective of the quality of care. Dr. Krause said not always. But he said when outcomes were consistently poor, it raised questions. Hale asked if Dr. Krause was aware that the defendant had performed thousands of successful surgeries over his career. Dr. Krause said he was aware. Hale asked if one complication or even several complications should define a surgeon's career. Dr. Krause said no. But he said 15 deaths were more than several complications. Hale had no further questions. Ortega called a series of expert witnesses. The first was a surgeon who specialized in quality review. He testified that he had reviewed all 15 cases. He said that in each case, the operative report minimized or omitted critical information about intraoperative complications. He said this pattern was not consistent with honest documentation. The second expert was a forensic pathologist. She testified that she had reviewed the autopsy reports for the patients who had died. She said that in several cases, the cause of death was directly linked to surgical errors that should have been preventable. She described one case in which a patient had died from a bowel perforation. She said the perforation had occurred in a section of the bowel that should not have been involved in the surgery. She said this suggested the surgeon had either deviated from the planned procedure or had been careless. The third expert was a biostatistician. He testified that he had analyzed the defendant's mortality rate compared to other surgeons performing similar procedures. He said the defendant's mortality rate was more than 3 times the national average. He said the likelihood that this was due to chance was less than 1 in 1,000. Hale objected to the statistical analysis. He argued that the defendant took on higher-risk patients, that his caseload was not comparable to other surgeons. The biostatistician said he had controlled for patient risk factors. He said even when adjusted for comorbidities, the defendant's mortality rate was significantly higher. Judge Navarro allowed the testimony to stand. The prosecution spent 2 weeks presenting its case. They called nurses who described warning signs that had been ignored, residents who described concerns that had been dismissed, family members who described loved ones who had been healthy before surgery and dead days later. They presented medical records, autopsy reports, expert analyses. They built a case that the defendant had repeatedly acted with reckless indifference, that he had prioritized his own convenience over patient safety, that he had falsified records to conceal his actions, and they presented evidence that the pattern had continued for over 15 years, across multiple hospitals, with no accountability. By the time the prosecution rested, the jury had heard from 37 witnesses and reviewed hundreds of documents. The case against the defendant seemed overwhelming, but the defense had not yet presented its case. Hale called his first witness. It was a colleague of the defendant, a surgeon who had worked alongside him for years. The colleague testified that the defendant was one of the most skilled surgeons he had ever known, that he was meticulous, dedicated, that he often took on cases that other surgeons would not touch. Hale asked why the defendant took on those cases. The colleague said because he believed every patient deserved a chance, even patients who were high risk, even patients who had been turned away by other doctors. Hale asked if that meant the defendant's patients were sicker than average. The colleague said yes. Hale asked if that could explain the higher mortality rate. The colleague said it could. Ortega cross-examined. She asked if the colleague had reviewed the specific cases that were the subject of the charges. He said he had reviewed summaries. She asked if he had reviewed the full medical records. He said no. She asked if he was aware that several of the patients who had died had been described as low risk before their surgeries. He said he was not aware of that. Ortega had no further questions. Hale called several more character witnesses. Each testified to the defendant's skill, his reputation, his dedication. But none of them could explain the pattern of deaths. None of them could explain the falsified records. Hale knew he needed to address the evidence directly, and there was only one person who could do that. He called the defendant to the stand. The defendant took the stand. He was sworn in. He stated his name for the record, Dr. Malcolm Reeves. Hale asked him to describe his background. Dr. Reeves said he had graduated from medical school 25 years ago. He had completed his residency at a prestigious hospital. He had specialized in general surgery. He had been board certified for over 20 years. Hale asked him how many surgeries he had performed over his career. Dr. Reeves said thousands. He said he did not have an exact count. Hale asked him why he had become a surgeon. Dr. Reeves said he had wanted to save lives, to help people, to make a difference. Hale asked if that was still his motivation. Dr. Reeves said yes. Hale asked Dr. Reeves to address the charges, to explain what had happened in the 15 cases. Dr. Reeves said that each case was different, but that they all involved high-risk patients. Patients with serious underlying conditions. Patients who knew the risks when they consented to surgery. He said he had done everything he could to save each of them. But sometimes, despite the best efforts, patients did not survive. Hale asked about the medical records, about the allegations that Dr. Reeves had falsified documentation. Dr. Reeves said he had never falsified anything. He said he had documented what he believed was important. That operative reports were summaries, not transcripts. That they captured the key moments of a surgery, not every detail. He said if he had failed to document certain complications, it was because he had been focused on managing them in the moment, not because he was trying to hide them. Hale asked about patient A's case specifically. Dr. Reeves said the blood vessel injury had been an unfortunate complication. He said he had repaired it during the surgery. He said he had believed the repair was adequate. He said the delayed bleeding had been unexpected. But it happens sometimes. Hale asked if Dr. Reeves regretted what had happened to patient A. Dr. Reeves said yes. He said he regretted any case that did not go as planned. Hale asked if Dr. Reeves had ever intentionally harmed a patient. Dr. Reeves said no. Never. Hale had no further questions. Ortega stood for cross-examination. She approached slowly. She asked Dr. Reeves how many patients he believed had died as a result of his surgeries over the past 15 years. Dr. Reeves said he did not have an exact number. He said mortality was tracked by the hospitals where he worked. Ortega asked if he had ever reviewed his own mortality statistics. Dr. Reeves said he had reviewed them as part of quality assurance processes. But he said he did not track them personally. Ortega asked if Dr. Reeves was aware that his mortality rate was significantly higher than the national average. Dr. Reeves said he had been told that, but he said it was because he took on higher-risk cases. Ortega asked if all 15 of the patients in this case had been high-risk. Dr. Reeves said most of them had been. Ortega asked him to identify which ones had not been high-risk. Dr. Reeves paused. He said he would need to review the records to answer that specifically. Ortega said she had reviewed the records. She said at least 6 of the 15 patients had been classified as low to moderate risk before their surgeries. She asked if Dr. Reeves disputed that. Dr. Reeves said that risk assessments were subjective, that a patient might seem low risk on paper but have hidden factors that increased their risk. Ortega asked if Dr. Reeves had documented those hidden factors in the operative reports. Dr. Reeves said not always. Ortega asked why not. Dr. Reeves said because he had been focused on the surgery itself. Ortega asked if Dr. Reeves understood that documentation was part of his responsibility as a surgeon. Dr. Reeves said yes. Ortega asked if he understood that accurate documentation was necessary for other doctors to provide appropriate follow-up care. Dr. Reeves said yes. Ortega asked if he understood that falsifying documentation could endanger patients. Dr. Reeves said he had never falsified documentation. Ortega asked about the email exchange with his colleague, the one in which Dr. Reeves had written, "These things happen. Can't save them all." She asked if Dr. Reeves remembered writing that. Dr. Reeves said he did. Ortega asked if he remembered that the email had been written after 3 patients had died in 1 month. Dr. Reeves said he did not remember the specific timing. Ortega showed him the email. She pointed to the date. She asked if 3 deaths in 1 month had concerned him. Dr. Reeves said of course it had concerned him. But he said all 3 patients had been extremely high risk. Ortega asked if Dr. Reeves had reviewed his approach after those deaths. If he had considered whether he might be taking on cases that were beyond his capability. Dr. Reeves said he had considered it. But he said he had concluded that the deaths were unavoidable. Ortega asked who had reached that conclusion. Dr. Reeves said he had. Ortega asked if anyone else had reviewed the cases. Dr. Reeves said they had been reviewed by the hospital's mortality committee. Ortega asked what the mortality committee had concluded. Dr. Reeves said they had concluded that the complications were within the expected range. Ortega asked if Dr. Reeves had ever disagreed with the mortality committee's findings. Dr. Reeves said no. Ortega asked if that was because the findings always supported his actions. Hale objected. He said the question was argumentative. Judge Navarro sustained the objection. Ortega moved on. She asked about the case in which a surgical instrument had been left inside a patient. She asked if Dr. Reeves remembered that case. Dr. Reeves said he remembered the case. But he said the instrument had been left by a resident, not by him. Ortega asked if Dr. Reeves had been the supervising surgeon. Dr. Reeves said yes. Ortega asked if the supervising surgeon was responsible for ensuring that all instruments were accounted for before closing the surgical site. Dr. Reeves said yes. Ortega asked if Dr. Reeves had failed in that responsibility. Dr. Reeves said he had relied on the count provided by the surgical team. Ortega asked if the count had been incorrect. Dr. Reeves said apparently it had been. Ortega asked if Dr. Reeves had documented in the operative report that an instrument had been left behind. Dr. Reeves said no. He said he had not known at the time. Ortega asked when he had learned that an instrument had been left behind. Dr. Reeves said when the patient died and the autopsy was performed. Ortega asked what Dr. Reeves had done when he learned that. Dr. Reeves said he had reported it to the hospital. He said the case had been reviewed. Ortega asked if Dr. Reeves had contacted the patient's family to explain what had happened. Dr. Reeves said the hospital had handled communication with the family. Ortega asked if Dr. Reeves had personally spoken to the family. Dr. Reeves said no. Ortega asked why not. Dr. Reeves said he had been advised by the hospital's legal counsel not to communicate directly with the family. Ortega asked if Dr. Reeves had wanted to communicate with the family. Dr. Reeves paused. He said he had not wanted to make the situation worse. Ortega asked if Dr. Reeves believed that speaking to the family would have made the situation worse. Dr. Reeves said he had not known what to say. Ortega asked if an apology would have been appropriate. Hale objected. He said the question was outside the scope of the charges. Judge Navarro overruled the objection. She said the defendant's state of mind was relevant. Dr. Reeves said he regretted what had happened. But he said an apology would not have brought the patient back. Ortega asked if Dr. Reeves had learned anything from that case. Dr. Reeves said he had learned to be more careful with instrument counts. Ortega asked if he had changed his practices as a result. Dr. Reeves said he had become more vigilant. Ortega asked if any patients had died from similar errors after that case. Dr. Reeves said no. Ortega asked if Dr. Reeves believed that meant he had been less vigilant before that case. Dr. Reeves said he had always tried to be vigilant. Ortega asked if trying was the same as succeeding. Hale objected. He said the question was argumentative. Judge Navarro sustained the objection. Ortega had no further questions. The defense rested. Closing arguments were scheduled for the following week. Ortega began her closing by reminding the jury of the scope of the case. 15 deaths. 15 families. 15 lives that had been cut short. She told the jury that the defendant wanted them to believe that these deaths were unavoidable, that they were the result of bad luck, of high-risk patients, of the inherent dangers of surgery. But Ortega told the jury that the evidence showed otherwise. She walked them through the medical records, the operative reports that minimized complications, the documentation that concealed errors, the pattern that stretched across 15 years and 4 hospitals. She told them that this was not bad luck. This was reckless indifference. She told them that the defendant had known his mortality rate was high. He had known that his patients were dying at a rate far above the national average. And he had continued anyway. She told them that the defendant had been confronted with concerns. Nurses had raised questions. Residents had raised questions. Colleagues had raised questions. And he had dismissed them all. She told them that the defendant believed he was untouchable, that his credentials, his position, his reputation, would protect him. But Ortega told the jury that the law did not recognize such protections. She told them that doctors were held to a standard of care, and when they fell so far below that standard that their conduct showed reckless indifference to human life, they could be held criminally responsible. She told them that second-degree murder did not require premeditation. It required only that the defendant had acted with reckless indifference to the likelihood that his conduct would result in death. And the evidence showed that the defendant had done exactly that. Ortega told the jury that the defendant had testified that he had never intentionally harmed a patient. But she said intent was not limited to conscious desire. Intent could be inferred from conduct, from a pattern of behavior, from a refusal to change course even when the consequences were clear. She told the jury that the defendant had known his patients were dying. He had known his mortality rate was too high. He had known that his approach was dangerous. And he had continued anyway. That, Ortega said, was reckless indifference. That was murder. She asked the jury to hold the defendant accountable. Hale stood for the defense. He began by acknowledging the tragedy of the case, the loss that the families had experienced. But he told the jury that grief did not equal guilt. He told them that the prosecution had asked them to criminalize medicine, to send a message that if a patient dies, the doctor could go to prison. He said that was not justice. That was vengeance. Hale told the jury that surgery was inherently risky, that patients died every day from complications, that no surgeon, no matter how skilled, could save every patient. He told them that the defendant had dedicated his life to helping people, that he had taken on the most difficult cases, the cases that other doctors would not touch. He told them that the defendant's mortality rate was higher than average because his patients were sicker than average. Hale walked them through the cases. He pointed out that many of the patients had multiple comorbidities, that they had been elderly, that they had been frail. He told them that the prosecution's experts had testified that the defendant's mortality rate was too high. But he said those experts had not been in the operating room. They had not faced the challenges the defendant had faced. He told them that it was easy to judge with hindsight, to look at outcomes and assign blame. But he said that was not fair. Hale told the jury that the operative reports the prosecution claimed were falsified were simply incomplete. He said doctors wrote summaries, not transcripts. He said they documented what they believed was important. He said if the defendant had failed to document every complication, it was because he had been focused on saving lives in the moment, not because he was trying to hide anything. Hale told the jury that the prosecution had not proven intent. They had not shown that the defendant had wanted his patients to die. They had not shown that he had deliberately caused harm. They had only shown that patients had died, and that the defendant had made mistakes. But mistakes, Hale said, were not crimes. He told the jury that if they convicted the defendant, they would be setting a precedent that would destroy medicine. That every doctor in the country would be looking over their shoulder, afraid to take on difficult cases, afraid to make the hard decisions that surgery required. He told them that the defendant was not a murderer. He was a surgeon who had tried to save lives and sometimes failed. Hale asked the jury to find the defendant not guilty. Judge Navarro instructed the jury on the law. She explained that second-degree murder required proof that the defendant had acted with reckless indifference to human life, that his conduct had been so extreme that it went beyond ordinary negligence. She explained that the jury would need to determine whether the defendant had been aware of the risks his conduct posed, and whether he had consciously disregarded those risks. She explained that the falsification charges required proof that the defendant had knowingly made false entries in medical records, and that those false entries had been material to the care of the patients. She reminded the jury that the defendant was presumed innocent, that the burden of proof rested with the prosecution, and that if they had a reasonable doubt as to any element of the charges, they must acquit. She told them to deliberate carefully. Then she sent them to the jury room. The jury deliberated for 6 days. On the second day, they requested copies of all 15 operative reports and the corresponding autopsy reports. On the fourth day, they sent a note asking for clarification on the definition of reckless indifference. Judge Navarro brought them back into the courtroom. She reread the relevant portion of the jury instructions. She explained that reckless indifference meant more than carelessness. It meant a conscious disregard of a substantial risk. She told them that they would need to determine whether the defendant had been aware that his conduct created a high probability of death, and whether he had proceeded anyway. On the 6th day, they sent a note saying they had reached a verdict. The courtroom filled quickly. Dr. Reeves sat at the defense table. His expression was tense but controlled. His wife sat in the gallery behind him. She had attended every day of the trial. She looked exhausted. The jury filed in. Judge Navarro asked if they had reached a verdict. The foreperson stood. He said they had. Judge Navarro asked the defendant to stand. Dr. Reeves stood. Hale stood beside him. The clerk took the verdict forms from the foreperson. There were 16 forms. One for each count. The clerk began reading. Count 1. We, the jury, find the defendant guilty of second-degree murder. There was a sound in the gallery. A gasp. A sob. The clerk continued. Count 2. We, the jury, find the defendant guilty of second-degree murder. Count 3. We, the jury, find the defendant guilty of second-degree murder. The clerk read through all 15 counts. Guilty. On every count of murder. Guilty. On every count of falsifying medical records. Dr. Reeves stood motionless. His face had gone pale. His wife covered her face with her hands. Judge Navarro thanked the jury for their service. She dismissed them. Then she scheduled sentencing for 8 weeks later. Sentencing took place on a cold morning in January. The courtroom was filled with family members of the victims. They had come to see justice served. Judge Navarro heard from the prosecution first. Ortega argued that the defendant had shown no remorse, that he had continued to deny responsibility, that even after the verdict, he had maintained that he had done nothing wrong. She argued that the defendant's crimes were not impulsive. They were the result of years of reckless conduct, of a conscious decision to prioritize his own convenience over patient safety. She asked the court to impose the maximum sentence, 15 years to life for each count of murder, to run consecutively. Hale argued for leniency. He said his client had spent his life in service to others, that he had made mistakes but he had never acted with malice, that he was not a danger to society. He asked the court to impose concurrent sentences, to recognize that his client was not a criminal in the traditional sense. Judge Navarro listened to both sides. Then she addressed Dr. Reeves directly. She said she had spent considerable time reviewing the evidence, the medical records, the testimony, the expert analyses. She said she believed the jury had reached the correct verdict. She said the defendant had been entrusted with the lives of his patients. That trust was sacred, and the defendant had violated it repeatedly. She said the defendant had known that his practices were dangerous. He had been confronted with evidence of his failures, and he had refused to change. She said that showed not just negligence but a conscious disregard for human life. Judge Navarro said the law recognized that some conduct was so extreme, so reckless, that it crossed the line from civil liability to criminal culpability, and the defendant's conduct had crossed that line. She sentenced him to 15 years to life on each count of murder. She ordered the sentences to run consecutively. She sentenced him to 2 years on each count of falsifying medical records, also consecutive. The total sentence was 240 years to life. Dr. Reeves would never leave prison. The defendant showed no reaction. His wife left the courtroom before the sentence was fully read. Hale immediately filed a notice of appeal. Dr. Reeves was taken into custody that day. In the months that followed, the case generated significant media attention. Legal scholars debated whether the verdict would hold up on appeal, whether it set a dangerous precedent for the prosecution of medical professionals. Medical organizations expressed concern that the case would discourage doctors from taking on high-risk patients. But patient advocacy groups hailed the verdict as a recognition that doctors were not above the law, that when their conduct crossed the line into criminal recklessness, they should be held accountable. The families of the victims expressed relief. They said the verdict did not bring their loved ones back, but it validated their belief that something had been wrong, that their loved ones' deaths had not been unavoidable accidents. They said they hoped the case would encourage hospitals to take quality concerns more seriously, to investigate patterns of mortality more aggressively, to act before more patients were harmed. 2 years after the trial, a journalist published a comprehensive investigation into the case. The investigation revealed that concerns about Dr. Reeves had been raised at every hospital where he had worked, but that those concerns had been handled quietly. Internally, the investigation found that hospitals had been reluctant to report problem physicians to medical boards, that they feared liability, that they feared reputational damage, and so physicians like Dr. Reeves had been allowed to move from hospital to hospital, carrying their problems with them. The investigation called for reforms. Mandatory reporting of mortality outliers, independent review of deaths, greater transparency in credentialing. Some of those reforms were eventually adopted. but slowly, and not universally. Patient A, who had survived Dr. Reeves' surgery and whose testimony had been crucial to the case, gave one interview after the trial. She said she had struggled with guilt. She said she had wondered if she could have done more, if she could have spoken up sooner. She said she had been told after her surgery that she was lucky to be alive, that she should be grateful. And she had been grateful, for a time. But then she had started to question, to wonder why she had needed emergency surgery at all, why the first surgery had gone so wrong. She said the hardest part had been realizing that her trust had been misplaced, that the person who was supposed to heal her had nearly killed her. She said she hoped her testimony had made a difference, that it had prevented other patients from experiencing what she had experienced. She said she still struggled with medical anxiety, that she had difficulty trusting doctors, that she researched everything, asked questions, requested second opinions. She said that vigilance was exhausting, but necessary. She said she wished she had been more vigilant from the beginning. The appeal was heard 3 years after the original trial. The defense argued that the verdict was not supported by the evidence, that the prosecution had failed to prove reckless indifference, that the deaths were consistent with unfortunate but expected complications. They argued that the jury had been influenced by the cumulative effect of multiple deaths, that they had looked at the pattern rather than evaluating each case individually. They argued that the judge's instructions had been flawed, that the definition of reckless indifference had been too broad. The appellate court reviewed the record. They issued their ruling 18 months later. They upheld the convictions on 12 of the 15 murder counts. They reversed the convictions on 3 counts, finding that the evidence in those specific cases was insufficient to support a finding of reckless indifference beyond a reasonable doubt. They upheld all of the falsification convictions. They remanded the case for resentencing on the reduced counts. Dr. Reeves was resentenced to 194 years to life. The practical effect was the same. He would never be released. Dr. Reeves gave one interview from prison. It was 5 years after his conviction. He said he still did not understand the verdict. He said he had been a surgeon. He had tried to save lives. He had sometimes failed. He said he did not believe that made him a murderer. The interviewer asked if he had any regrets. Dr. Reeves said he regretted the outcomes. He regretted that patients had died. But he said he did not regret his approach. He said he had done what he thought was right at the time. The interviewer asked if he had anything to say to the families of the patients who had died. Dr. Reeves said he was sorry for their loss, but he said he did not accept responsibility for it. The interviewer noted that Dr. Reeves spoke calmly, without emotion. He seemed detached from the magnitude of what had happened. He seemed certain that he had been wronged, that the verdict had been unjust. He did not seem to recognize that his certainty had been the problem all along. The case files remain in the archives of the county courthouse. They are referenced occasionally, in legal briefs, in medical ethics courses, in training for hospital administrators. The case is cited as a warning, a reminder that patterns matter, that outliers should be investigated, that silence protects the wrong people. But it is also cited as a cautionary tale about the criminalization of medicine, about the dangers of hindsight bias, about the difficulty of proving intent in complex professional settings. The debate continues. But for the families of the victims, the debate is academic. They know what they lost. They know that their loved ones trusted a doctor who failed them. They know that the system failed to catch the pattern until it was too late. And they know that no verdict, no sentence, no amount of accountability can bring their loved ones back. One family member, the daughter of a woman who had died following surgery, spoke at a victims' rights conference several years after the trial. She said the hardest part had been the uncertainty. Not knowing whether her mother's death had been preventable. Not knowing whether someone should have seen it coming. She said the trial had provided answers, but the answers had been devastating. She said her mother had been healthy before the surgery, that the surgery had been elective, that her mother had trusted the surgeon when he said it was routine. She said her mother had died 3 days after the surgery, from an infection that had started in the surgical site. She said the autopsy had shown that the infection had been caused by contamination during the surgery, that proper sterilization protocols had not been followed. She said the operative report had made no mention of any concerns about contamination. She said her mother had died believing the surgery had been a success, that her pain was normal, that she would recover. She said she wished her mother had known the truth, but she also understood why she hadn't, because the truth would have been terrifying. The truth was that she had been harmed by the person who was supposed to protect her, and there had been nothing she could do about it. The daughter said she had testified at the trial. She had described her mother, her strength, her optimism, her trust. She said she had looked at Dr. Reeves while she testified. She had wanted to see some sign of remorse, some acknowledgement of responsibility. She had seen nothing. She said that absence had been more painful than anything else, because it meant he did not understand what he had taken. He saw patients as cases, as statistics, as acceptable losses. He did not see them as people, as mothers, as daughters, as lives that mattered. She said the verdict had been important, but it had not healed the wound. Nothing could. The conference organizer asked if she had any advice for other families who were navigating similar situations. She said she had learned to ask questions, to trust her instincts, to demand answers. She said she had learned that doctors were human, that they made mistakes, that they sometimes prioritized their own egos over patient safety. She said she had learned that systems were slow to act, that hospitals protected their own, that accountability often came too late. But she said she had also learned that silence was complicity, that when something felt wrong it was important to speak up, to demand investigation, to refuse to accept explanations that did not make sense. She said her mother had not had that opportunity, but she could honor her mother by ensuring that others did. The case is over. The verdict stands. The sentence has been served, in the sense that Dr. Reeves will spend the rest of his life in prison. But the questions remain. How many other doctors are practicing with mortality rates that are too high? How many hospitals are quietly managing concerns instead of reporting them? How many patients are dying because the people who are supposed to protect them are not being held accountable? And how many families are being told that their loved ones' deaths were unavoidable, when the truth is more complicated? When the truth is that someone made a choice to take a risk that should not have been taken, a choice to prioritize something other than patient safety, a choice that cost a life. This was the story of a surgeon who believed his credentials made him untouchable, a surgeon who spent years making mistakes that killed patients, and the one patient who survived long enough to expose the truth, a truth that had been documented all along, in medical records that did not match reality, in mortality statistics that were ignored, in concerns that were dismissed, until one surgical report contradicted what a patient remembered, and suddenly the pattern could no longer be denied. The case file is closed, but the work of preventing the next case continues. One mortality review at a time, one quality audit at a time, one moment of courage at a time, until hospitals prioritize patient safety over reputation, until doctors are held accountable for patterns of harm, until no patient has to wonder if their trust was misplaced, and no family has to learn too late that their loved one's death was preventable.